Hello, hello. Good afternoon, everyone. This is Ifeoma Odunlami, immigration attorney from the Odunlami law firm. How are you guys doing this beautiful Tuesday? All right, I'm going to wait for people to come in. I have a great topic, so join me. Let's get to it. All right, and when you join, please say hello. Let me know you're here. And at the end of my presentation, I will be happy to take questions. All right. All right. So, how's everyone doing? Good morning. Good afternoon, Instagram. Good afternoon, Facebook, YouTube, and TikTok. My newest live community. I hope you guys are doing great. Oh wow! Thank you, Zini. I appreciate. Hello, Nemeka Onyejekwe. How you guys doing? All right. So I'm excited to talk today about this topic, which I know many people will enjoy. And pardon me, I'm going to be coughing a little because I'm feeling a little under the weather. So just as I would say in Nigeria, just manage me like this. So I wanted to talk about the permanent green card, the 10-year green card. And one of the frequently asked questions I get are from people whose 10-year green card have been denied. So they had a conditional green card, they removed the conditions, applied for the 10-year green card, and it was denied, and they don't know why. So that's what we're going to talk about. And for those who are just signing on, let me introduce myself again. My name is Ifeoma Odunlami. I'm an immigration attorney in New Jersey, but my clients span the whole 50 states of New Jersey because immigration is federal law. We also even assist people who are outside the United States if they need immigration assistance coming in here, right? We do family-based humanitarian, and we're here to assist you guys. We're a law firm of immigrants assisting other immigrants. So if you need to reach out to us, the phone number to call is 973-993-1900. Please make sure that's the number you're calling. We have another number for people who when they become our clients, but this is the number you should be reaching out to. Don't let yourself get scammed by all these unscrupulous people out there. So I get this question all the time. So let's start from the beginning, all right? So you get a temporary green card if your marriage to your U.S. citizen or green card holder spouse is less than 2 years at the time you get the green card. So if it's less than 2 years at the time you get your green card, you're going to get a 2-year green card. And that 2-year green card is only good for 2 years. So 90 days, within 90 days of the expiration of the green card, you're supposed to remove the conditions, right? And the way to remove the conditions is to file the form I-751 and then put in all the evidence they're looking for. We're going to talk about what evidence they're looking for. And then when you do this, typically you're supposed to do it with your spouse. But sometimes the marriage does not survive for many reasons. And so there are waivers which allow you to do it on your own. Okay? So I want to talk about that really briefly because I see this is a problem I see that you guys, honestly, I'm about to spill gold here. Listen, I need you to listen to this because I had a consultation the other day and this person was married to a U.S. citizen, got the temporary green card, and shortly after they got their temporary green card, the marriage, didn't work out. And instead of moving right away to get a divorce so that they could at least use the divorce waiver, they waited, did nothing. And then, now USCIS is giving you is there a 4-year extension? So for a long time, you're here waiting, thinking that, well, they haven't called me for an interview. I guess everything is okay. It's not okay. So what happened was that they gave her an interview just with maybe 2 weeks notice. And at this point, she had no waivers. So if you are in a relationship and that relationship is not working out, you have options and you want to exercise these options as soon as possible, right? Option number one, if the relationship is not working out anymore because you now have been divorced, file the I-751 as soon as you get your divorce decree. Put it in, and then USCIS is going to be looking for you to show that that marriage that no longer worked, but at least when you married him and it was viable, it was a good faith marriage. Excuse me. Or if you've been abused in the relationship or treated with extreme cruelty, you can file a waiver based on extreme cruelty or physical abuse, if that's the case. Or if the person has passed away, right, you can file a waiver based on that. You don't have to wait. Once these events happen, you don't have to wait until it's 2 years before you file to remove the conditions. You can do it right away. And then the last waiver would be the waiver of exception of extreme hardship. You have to show that within the 2 years conditional period, you had extreme hardship that would make it difficult for you to go back to your country, right? So I've mentioned 4 exceptions now, right? I'm going to go over them again. So typically, if you have an I-751, you need to remove your conditions. You're supposed to do it with your spouse. But if the relationship doesn't last for one reason or the other, act quickly to work on the waivers, because you don't want to get to a situation where you could get called for an interview and you have no waiver and your spouse is not showing up to remove the conditions with you. And at that point, they will deny the I-751, even if you have hospital records showing that you were abused by this person. And if you're lucky, the officer may allow you the opportunity to go back and produce evidence of the abuse, right? But you want to be prepared. So if you have a spouse who's threatening you with divorce, don't be afraid. Get the divorce and file for your 10-year green card. But a lot of people feel that the U.S. citizen or green card holder has this power and they need that person to file jointly with them, and you don't. I keep saying this, you do not. So I need for you guys to understand this. I need for you to let people who are, afraid that their spouse will divorce them to know that they can do it on their own. And so that's what you need to do, right? And another thing, actually, even if you're divorced from your spouse or you're separated from your spouse and it's not working out anymore, if your spouse is still happy to remove the conditions with you jointly, you can still remove the conditions jointly with your spouse, even though the marriage is not valid. Now, a lot of officers don't know that you're allowed to do this, so expect that there's going to be some pushback where they say you're not together anymore, so I'm going to deny it. No. If you're not together anymore, but you can prove that it was a bona fide marriage and your American spouse or green card holder is still willing to remove the conditions with you, that's something you can do. But I'm going to advise you to get a lawyer if you're going to pursue that, because sometimes some officers will push back until we send them the law. All right. So a lot of times people feel that because they got their permanent green card, their temporary green card, that they don't have to work so hard for their permanent green card. As a matter of fact, that is so wrong. The permanent green card is actually harder, in my experience, to get. That is, a permanent green card is harder to get than the temporary green card, because sometimes they don't even call you for an interview for a temporary green card. But when it's time to get your 10-year green card, a lot of times, if you were not called for an interview the first time, you may expect that they will call you for an interview to take a look at your relationship. And even if they don't call you for an interview, it has to be because you provided copious evidence of a bona fide marriage. So the requirement of showing that it's a bona fide marriage does not end because you got a 2-year green card. As a matter of fact, you need to continue to show that from the time you got your green card up until the time you submitted your I-751, that the marriage was viable. Now, if the marriage was not viable or was not ended, then you need to show that as of the time you got your green card to the time the marriage ended, it was a real marriage. It was a good faith marriage, which means that you married this person because you wanted to be with them, not solely for immigration benefits, right? So a lot of times the I-751 is denied, even though you've given them everything you have. And then you ask, but why? So I'm going to go over a couple of reasons why your permanent green card was denied. So number one, it could be lack of evidence. You're not providing enough evidence. A lot of people make this mistake. they submit the same evidence they submitted to get the temporary green card, and they don't have anything to show that the couple continued to be in marital union after they got the green card. Or sometimes before they got the green card, the couple had already separated, right? So it's important that when you are submitting your I-751 removal of conditions, you must show that it was a bona fide marriage. In fact, there are four waivers. 3 of them require proof that you had a bona fide marriage, and that would be the waiver of divorce, the waiver of death, the waiver of extreme cruelty or physical abuse. You still need to show it was a bona fide marriage. Now, the only waiver that doesn't require you to show a bona fide marriage is the last one, which talks about extreme hardship to you if you don't, if you're not allowed to stay in the United States. So some of the reasons that you may have been denied your I-751 is because you haven't provided the right evidence to show that it was a bona fide relationship. And what evidence is USCIS looking at? They're looking at proof of financial commingling. Did you live together? Do you have joint assets, joint bank accounts that were being used by both of you? Do you have health insurance, car insurance, life insurance together with each other's beneficiaries? Do you have, what else? Tax, did you file your taxes together? Do you have joint retirement plans? Things that show that your finances are commingled. They love that. Now, does that mean that if you don't have that, you're not going to get your green card? It doesn't mean. It's all evidence is always what is suggested, right? And if you don't have one, if you don't have one, mortgage, yes. If you have a mortgage together, that's excellent. If you don't have one, then you need to be able to show why you don't have that and show the other ones you have. For instance, if for some reason you don't live together, you have to explain it up front. Don't wait for them to send you a notice of intent to deny. Explain up front. I was in school in Kentucky, and so I only came home to the marital home during the holidays. But here I can show that we were visiting each other. Here, airline tickets. Here's the show we went to. Here's a vacation we took together. Here's a Christmas party at my spouse's boss's home. Just bring things together to tell a story of your life together, okay? So another reason that you may have been, before I forget, affidavits. Affidavits can be important, but affidavits, which is affidavits from friends and family that know that you're a genuine married couple, cannot replace evidence. I want you to hear that. It cannot replace evidence. And so it's helpful, right? But they're still looking for other things. So to make an affidavit of bona fide marriage really helpful to you, you want to make sure that the affiant, the person who's writing the affidavit, is hitting the key points. Because I see a lot of affidavits which sound like, like boilerplate language. They don't want that. First of all, the person who's writing the affidavit must identify themselves, their name, address, date of birth, where they live, contact information, because sometimes USCIS will contact them. And then they need to talk about how they know you guys and why they think this relationship is valid. So this is a good opportunity for them to talk about their relationship with you as a couple, and then of course they have to sign off the affidavit with, I certify that the above is true to the best of my ability. I understand that if the above statements are not true, I'm subject to I'm subject to perjury charges or whatever, and then sign it before a notary public. With your affidavit, you also should attach an identification, an ID card, and if you have pictures showing you and the couple doing things together, that's also helpful. All right. So now another reason that you can get denied for your I-751 is maybe you filed too early. Remember, it's 60 days to the expiration, not before that. And sometimes some people don't submit because they forget until it's expired. Now, the good news is there's nothing to, there's no calamity if you didn't submit it before it expired. But when you file to renew it, which you should as soon as you can, because you do not want to go into deportation proceedings, you should explain why you didn't submit it then. A good faith explanation will suffice. All right. Now, another reason is criminal activity, right? If you've committed a crime, which could be either a crime involving moral turpitude or an aggravated felony or anything that could be a reason why your I-751 is denied. And as a matter of fact, that can make you deportable. Remember that having a green card does not mean that you cannot be deported. If you have a green card, you can still be deported, right? And another reason why USCIS will deny your I-751 is if they believe the marriage is fraudulent. And a fraudulent marriage is a no-no. If you ever get a fine of a fraudulent marriage, which is a 204C, Google it. It's a harsh penalty for people who get involved in sham marriage, sorry. You don't want to do that. That's for starters. And I talk about this a lot, because when immigrants come to the United States, there are people who are giving them advice, bad advice. And the immigrant doesn't know any better, and they think it's, this is what I'm supposed to do. No, the law is the law. You don't break the law because you're trying to get an immigration benefit. There are consequences. So we've seen people who have been found to have a sham marriage, right? And basically they cannot get a green card again. And there are people who have been found to have had a sham marriage in error, because USCIS is not always right. And one of those cases we had a client that we won their VAWA case. This was, I think, a week ago or 2 weeks ago. I talked about it, that she had been in a relationship with a US citizen, and USCIS had concluded falsely, based only on the statement of the US citizen, that it was a sham marriage, and it was not true. And we provided proof, copious proof, of the fact that it was a bona fide marriage, and they still denied it. So we sued them, and it was approved. So if you are in a bona fide marriage and USCIS wrongfully made a determination that your marriage was a sham marriage, you should not let it go. You should talk to an attorney. Excuse me. You should talk to an attorney, because a sham marriage is almost, it's the death knell of getting a green card. So now, let's see. So what else? I-751s, like I said, are be prepared, right? And when we tell people to have consultations with attorneys, right, it's really because everybody's case is different. And when you talk to an attorney, sometimes they're able to help you think outside the box to figure out a way to, preserve your evidence. And this is a good time to tell people that if you have somebody filing for you, make sure you get a copy of your documents. I can't count how many people come for consultations and they don't really know what was filed for them. And they're not lawyers, which I understand. So they don't really have an understanding of what was done. But if I see the records that you submitted, it helps. If it's not helpful, then I would get a FOIA to review it, because sometimes you cannot move to the next step until you know what happened in the previous step. So it's important for you to make sure you have your records. And if you have an attorney or whoever is working on your case and they prepare it, make sure you ask them for a copy. And I want to issue this warning, because I tell you, some of my consultations really break my heart, because people are just being given wrong information. If you have somebody who's telling you to break the law, who's actively trying to get you to lie, trust me, that is not somebody that should be filing your papers, because you're not the first person that they're encouraging to tell these lies. You're not the first person that they're filing false documents for. And trust me, you don't even know if USCIS already has an eye on that. So that when you submit your documents from this person, if there's an investigation, you become a part of it, you know. And you are there just following this person because your sister's husband told you this is the person to use, and you use them, but you didn't know this person already had some was duplicitous, and things. USCIS had kept an eye on them. So it's important that you get advice from people who actually practice law, who actually practice immigration law full time, and who keep up with the changes in immigration law. All right. So with a 9751, you may get called for an interview. Great. If you don't, um, you know, great too. You take your green card, right? Your 10-year green card. But remember, even when you get your 10-year green card, remember USCIS can still look at whether you got this green card rightfully, properly when you go for your naturalization interview. We've had people that came for consultations that by the time we review their case, we're like, if you file for naturalization, they're going to take your green card from you because you might have, sometimes it's usually something with them saying that they didn't have a child that they did, not putting the names of all their kids. And I never understand why people do that, because somebody has advised them to, oh, if you put all your kids' names, you won't get it. That's not true. You cannot be dishonest about how many children you have, whether you've been married before, because those are the little things you think don't make a difference, but it actually can sink your case. So how do you have a child that you never claimed was your child, and then you've naturalized, or you're trying to naturalize, and you now want to include them? That's going to get you deported straight up. So if somebody tells you not to include somebody's name or anything, that's not advice you should be listening to. All right. Talk to a proper lawyer who's ethical, that will tell you the proper thing to do. All right. Because some cases that would have been really easy wins become complicated because of a little lie that was told. And sometimes lies such as, you want to come to the United States, you say you were married when you were not married. Now, those lies, we can actually help because we can file waivers, right? But, there are other lies that there's nothing anyone can do, or some laws that have been broken that nothing anybody can do, such as pretending to be a US citizen, getting a job and claiming to be a US citizen, or using the identity of somebody who's a US citizen, or voting in a federal election. Nobody can help. That's a permanent bar, subject to very, very little exceptions. Okay. So let me take a couple of questions. Let's start. Okay, hello, Prince Mark. Hello, Harvey. Hello, Julie Allen. Hello. So Koda says, my sister wants to apply for a green card for her parents. So Koda, your sister has to be a U.S. citizen to be able to apply for a green card for your parents, okay? So Globemaster says, dear attorney, what's next after prima facie determination letter received? What are RFE, usually USCIS issues based on VAWA? Also, do you need to turn in pay stubs, 693 tax returns with I-485 application? That's a lot of questions. So I'm going to break it down. So what's next after prima facie determination letter? So sometimes you get your work permit and travel permit after the prima facie determination letter. Sometimes you get it before. So, but typically, when you file a VAWA, if you file it with an adjustment of status, after the prima facie or before the prima facie, you're looking to get your work permit, you're looking to get your travel permit. And then after that, you're just waiting for them to make a decision. Now, sometimes RFEs come. Typical RFEs could be RFEs regarding good moral character, like if you submitted your VAWA and you didn't put proof that you're good moral character, such as FBI report, local police clearances. I get a lot of RFEs when people have been here less than 3 years and they don't provide police clearance from their country. So if you've been here in the United States 3 years as of the time you filed the I-360, that 3-year period, USCIS wants you to submit a police clearance to show that you don't have any criminal history, and also affidavits from family members, from organizations that you worked at, from your local pastor, imam, can also work, from your friends, to show that you're a person of good moral character. So the RFEs could be that. RFEs could also be proof that you were properly divorced in your prior marriage, because if your prior marriage was not properly terminated, then the subsequent marriage with a U.S. citizen is void. And sometimes USCIS does not catch it on the first time, but when sorry, let me go back. This is VAWA. I was going on I-751. So sometimes USCIS is looking for you to show that your current marriage is legal. It's legal because you're properly divorced. It's legal because the person, your spouse, was properly divorced. Or in the case of VAWA, if your spouse, the U.S. citizen, is not properly divorced, you can prove that you knew nothing about that, and when you had a proper marriage, like a legal marriage, you can get the benefit of the bigamy exception. But typically, the intending immigrant must show that they're properly divorced. Otherwise, you cannot get VAWA. You cannot get a VAWA approval. So RFEs will ask for you to show that you were properly divorced. They can also ask for you to show that the marriage is bona fide. Maybe what you submitted wasn't a lot, right? And they were not convinced it was a good faith marriage. So if you don't have any other thing, you have to be able to explain why you don't have any other evidence. Sometimes it's as a result of the abuse. Maybe you have a spouse who is keeping things from you, refusing to open a joint account, or maybe they owe child support and your money keeps getting taken away, or maybe your spouse wouldn't put you on the lease. Whatever it is, if you don't have bona fides, you have to explain it. And the standard is just credible evidence, okay? Now, going to the other question, do you have to turn in pay stubs 693? Pay stubs really goes to, I guess, I don't know what you'll be using pay stubs for in a VAWA case, but if it helps your case, you're trying to make a statement about it, then submit it. 693, which is a medical form, you should submit that now because there's no expiration. So, but in the past, we wouldn't submit the 693 form with the VAWA because VAWA takes about 3 to 3.5 years. But now you can submit it at the same time because it's good. It's basically good. Let's see. Coda says, parents want to only stay in US for 2 or 3 months every year. How it works? Can they go and come every 4 months? So Coda, if your sister is filing for your parents, they need to know that the laws require them to be in the United States for at least 6 months out of every year, because they cannot stay outside the United States for longer than 6 months. That's just the way it is. Now, if maybe they're not ready to come to the United States, maybe they want to, do other things and then come in later, they can get a re-entry permit, which allows them to stay outside the United States for 2 years. But if they're not ready to live in the United States for at least 6 months, 2 or 3 months every year is not going to work. All right. Let me take some questions from Instagram, and then I will go back to. Thank you, Solomon. Thank you. Good. Laura says, good afternoon, ma'am. I sent you DM, but no response. I don't see my DMs because I don't have, I don't respond to DMs. If you sent a DM, send it to my Instagram account. My team will respond to it. All right. Hello from San Antonio, Texas. Let's see. All right. Aziz Solomon says, hi, madam. I called your office last week and they promised to get back to me, but they never did. Oh, I'm sorry about that, Aziz. I will, can you call again? Because I don't know your full name, because otherwise I'll tell them to give you a call. So if you call again, please, somebody will get back to you. All right. All right. So I'm looking for questions on Instagram. So somebody said they call from Fresno, but no answer. What number are you guys calling? Is it 973-993-1900? That's the only number you should be calling. because Magda says, I have a niece that was deported, all the family in the US. How can we file a green card for her? Well, Magda, it depends on why your niece was deported. Without knowing why she was deported, I cannot tell you if it's possible for her to come back, okay? All right. All right, let's see. Let me go back to YouTube. So Koda says, I have my 2 years green card interview waived. Will I also get a chance to get the 10-year green card interview waived too in the future? Koda, nobody knows the answer to that. Let the future take care of itself because we don't know what the policy will be at that time. So Bolly Holly says, how long does it take for TPS? I applied in March. It's almost 5 months. No updates. Sometimes it takes a while, Bolly Holly. I mean, we've had TPS applications take, honestly, up to a year. And then some go really fast, so I don't really, it really depends. Agnes says, when my daughter gets her 10-year green card, can she apply for me? Only a U.S. citizen can apply for parent, Agnes. So what's going to happen is when your daughter gets her green card, after when she's had a green card for 3 years, if she got her green card through marriage to a U.S. citizen and she's still in a marital union with that spouse, then she can apply to naturalize. When she naturalizes, then and becomes a U.S. citizen, then she can apply for you. Ishmael Bully says, please do you do T visa? Yes, Ishmael, we do a lot of T visas, a lot of T visas, a lot of U visas, a lot of SJIS, and a lot of VAWA. So if you need an attorney for your T visa, which is for trafficking, please give us a call, 973-993-1900. So Ashi says, hello, I have a consultation with you scheduled 8:15, but I want to know if I can change it to sooner than that. Ashi, I don't think so. I mean, you can, because I'm going to be traveling for a couple weeks, about 10 days, which is, I will be back in the office on the 13th. But if you want, but my the other attorney in my office, Attorney Talitha, is available. She can do a consult. If it's an emergency, call the office again and see if they can squeeze you in. But honestly, it's a really tight squeeze before I leave because I'm leaving to travel shortly, okay? So B. Martha says, is it advisable to go for asylum after being in the States for 5 months? Trying to get work authorization. So B Martha, I want you to understand that getting a work authorization is not the reason to file asylum. You should file asylum because you have a fear of persecution in your country if you were to go back. Because when your asylum is denied, your case will be referred to immigration court, must be referred to immigration court. And yes, asylum takes a long time, so a lot of people are able to work here, stay here, and hopefully they're lucky they have another pathway that will help them if they end up going to immigration proceedings. But I just want you to know that getting a work authorization is not the basis for an asylum, and filing for asylum will put you, if denied, in immigration court for deportation, all right? So somebody says, and this is a great question, what's the next step after I-751 gets denied due to a missed interview? So file the I-751 right away, like urgently, because if you don't file the I-751 right away after you've missed the interview, they could put you in immigration proceedings. So you want to file it right away, and you want to give an explanation as to why you missed it. And it just has to be a good faith explanation. It doesn't have to be anything, any long, complicated story, okay? So go ahead and file it right away. If you want us to assist you, give us a call, 973-993-1900. All right. Let's see, one more question from Rahimat. So good afternoon. For the SIJ, how does a predicate order work? Does an immigration lawyer do that, a family lawyer? So typically it's an immigration lawyer that, I don't know if family lawyers do that, but we do our family petitions for the predicate order because it's part of the immigration case. I don't know any family lawyer that does a predicate order, that does SJIS predicate order work. Oh, everyone I know that does it is an immigration lawyer, but does that mean that they don't? I'm sure there are lawyers who have learned how to do it, but I don't know. There's no shortage of immigration lawyers that can assist you. So why don't you go to an immigration lawyer, Rahimat? Um, so let's see. So Rachel says, after getting a green card through marriage, but previously had asylum, can I travel to a country neighboring my home country to see my children? Also, am I allowed to use my home country passport? So Rachel, as you know, if you file for asylum, I would not recommend you going to your country. All right. With regards to whether you can go to neighboring country, I really can't give you advice on that because I don't know your case. I actually have, some strong views on certain things, and I need to get more information before I can advise you, because I don't want to tell you something and then you act on it and I didn't get the full story when I gave you that information. So I'm not giving legal advice. This is just for informational purposes. If you want legal advice, you need to call an attorney and get proper legal advice. The number to call if you want us to assist you is 973-993-1900. Okay, Rahimat, look forward to seeing you, okay? Awesome. So some questions here are really hard to understand. So simply Madukwa says, how long does it take to get an EAD after I-751 was denied due to paying the wrong visa fee? It depends. It really, really depends. So, I mean, typically I-75, you could anywhere from 3 months to 10 months. So you're basically going to refile it again. That's what it is. Okay, so how long did it take you the last time? Maybe that's how long it's going to take this time. So Gullyman says, my mother is in this country for 40 years. Now, if me and my sister file for her, does she have to go back to her country? So Gullyman, honestly, you would need to talk to an attorney because your mother may even be able to qualify on her own without needing you guys to file for her, right? That's number one. And I'm assuming that for some reason you guys haven't been able to file for her for 40 years. And I'm wondering, is it because she came in through the border, which of course means that she's not going to be able to adjust her status. She has to file a waiver and leave, right? Or does she have any other inadmissibility? You would want us to screen your mother properly to see if you guys can file for her or if she qualifies for another pathway if she's inadmissible for some reason, okay? And this is actually really important because a lot of people come to our office and, they've been here for so long and we're able to screen them for the different type of visa. We've been really successful screening people for T visas, trafficking visas, because a lot of people who have come here have a story with somebody who either brought them here to the United States or who employed them and took advantage of them because they were undocumented and forced them into some kind of involuntary servitude and, basically traffic them. So if that person can file for a T visa, guess what? They can get their green card. They can become U.S. citizens. They would not have to leave the United States. So that's something that you want your mom to be screened for. Okay. So give us a call, 973-993-1900. Okay, guys, I'm going to take a couple of questions from TikTok. TikTok, I didn't forget you. It's just so tiny. It's hard to read. So let me at least see if I can grab one question here. So somebody says, how long does this process to get married to a citizen for your temporary green card? It really varies. We've gotten people their green card in a marriage-based situation within 3 months. Sometimes it's taken a year. It really depends. Sometimes, it takes a long time based on where you live. Sometimes, based on the manner of the evidence provided, the officer may decide that, they're going to make a decision on this case right away. So it really depends. I would tell you that typically, let's put your expectations at like a year, okay? Anywhere from, I'd say, 6 months to a year is about average. All right. So someone says, is there a time for Department of State to provide FOIA information for unusual circumstances? Let me tell you, that Department of State FOIA, they take a while. They take a long time. And sometimes they don't even provide it, So, I don't know. Let's see. So Hoya says, for SJIS, how do you get the special findings? Can you explain the steps? So with the special findings, that takes place in family court, right? You are, depending on what state you are, there are different requirements. Like New York has different requirements, New Jersey has different requirements. But basically, this is what the lawyer is gonna show. The lawyer is gonna show that the child is unmarried, under the age of, well, in New Jersey and New York is 21, but in some states it's 18, in some states it's 19. So depending on the state, that would determine. Sorry guys, I'm a little tired because I don't feel well. That would determine the age limitation. So let's assume under the age of 21, because it could be, New York and New Jersey. So you have to show that that child is under the age required by the state, and you have to show that the child has been abused, abandoned, or neglected by at least one parent. Remember, it does not have to be both parents, at least one parent. And the abuse does not have to have happened in the United States. It could have happened when they were home, right? And then you have to show that as a result of this abuse, abandonment, or neglect, there can be no reunification with the abusive parent. And remember, in some states, abandonment, death of a parent is an abandonment. And then you also have to show, number 5, that it's better for the child to stay in the United States than to go back to their country. And so when you prepare this, you do it by way of getting a certification from the parent, getting a certification from the guardian who is seeking, guardianship of the child. You also do the certification of the child, and then prepare a legal brief where you make your argument and submit with whatever the state requires. And then typically you're called for a court hearing. You go for the court hearing and present the case, and the judge makes a determination. If the judge approves the case, they will issue a predicate order, and that's what you file with immigration. All right, guys, I'm really tired today. I'm tired today because I don't feel good, but I wanted to reach out and do a live with you guys and talk about I-751s. I haven't talked about that in a long time. So the important thing to remember is, do not take your I-751s for granted. Don't assume that because you got a temporary card that you're going to get the permanent card. You have to put work in making sure you present a really, really strong case. All right. And wish you the best. If you need our assistance, feel free to call us 973-993-1900. Take care. Bye-bye.